Recording in progress.
Good morning, honorable members.
Good morning, Honorable Chair.
Good morning. Good morning, Legal Services of the Parliament of the Republic of South Africa.
Good morning, Chair.
To the acting SecDef and all the generals present in the meeting, the support staff, and the parliamentary liaison officers representing the members of the executive. Let me also acknowledge, I'm going through my list. Honorable members are here. Honorable Minister, you are also welcome to our meeting. I see you are present. I'll acknowledge members as they come in. You are all welcome to today's meeting. Today's meeting, we are dealing with an outcome of the Concord that requires that we amend some pieces of our legislation, not the whole act, but the court was specific on what we need to amend, in particular 101 and 102, 15 and 17. Those are the 4 points highlighted by the Constitutional Court that we need to work on. But I'm sure Legal Services will advise in terms of how it snowballs or replicates to other sister acts within the department. But that will be a matter that we'll discuss. You are all welcome. That is the agenda before us. Opening and welcome. Number 2, it's apologies. Number 3 is briefing by the Parliamentary Legal Services on the Constitutional Court ruling. Number 4, it will be briefing by the Department of Defense on any planned legislature amendments to address the Constitutional Court ruling, including relevant envisaged timelines for the finalisation of the bill. Then we'll have consideration of minutes, then closure. That is the agenda before us. From the side of the Secretariat, before I adopt the agenda, is there, let's first adopt the agenda. Can we get a mover and a seconder for the agenda adoption?
I move, Chair.
Honorable Carl moves. Any seconder? All right, Honorable Hala seconded. Accept? Honorable Hala? All right.
I second.
Thank you. Okay, you second. Thank you. Thank you very much. Nandipa, any apologies?
Good morning, Chair, Minister, honorable members, and colleagues. There's only one apology from Ms. Sokanile. She is still at the doctor. She will join the meeting later, Chair. That's all.
All right, thank you very much. Apology accepted. If it's a doctor, we can discuss it. It's a private matter. Then we can move to Parliamentary Legal Services to brief us on the Concord ruling and its implication to our current legislature architecture. Thank you very much. Over to you.
Good morning, Honourable Chairperson, Honourable Members, Minister, departmental officials, colleagues. My name is Clara Williams. Thank you so much for this opportunity to present our Lacunae project to you this morning. I'm joined in this meeting by the Senior Parliamentary Legal Advisor, Advocate Charmaine van der Merwe, and Parliamentary Legal Advisor, Sean van Breda. Honourable Chairperson, I'm now going to switch off my camera and flight my presentation if that is in order.
Yes, you can proceed.
Thank you so much, Honourable Chairperson. If you can just perhaps confirm that you can see my screen, please.
Yes, I do. I hope all members can see the screen.
Thank you so much, Honourable Chairperson. So my presentation will provide some background on the Lacuna project, and my colleague Sean from Bradar will present on the lacuna in the Military Discipline Supplementary Measures Act and the Defence Act. As part of our mandate, our office considers lacunae, defects or gaps in the existing law identified by various institutions, including the Constitutional Court. We aim to empower committees to exercise increased oversight over the National Executive by monitoring their initiation and preparation of legislation, so these are executive bills, and to draft committee bills. In this regard, we considered lacunae in legislation administered by the Department of Defence. The aim of the memorandum we submitted to the Honourable Chairperson and this presentation is to advise the committee on the lacunae in the Military Discipline Supplementary Measures Act and the Defence Act and how it can be managed by exercising oversight over the department or by drafting legislation. With regard to the committee's oversight powers, Section 85(2)(d) of the Constitution states that the President exercises executive authority together with the other members of Cabinet, ministers, by preparing and initiating legislation. Cabinet members and deputy ministers may introduce executive bills in the National Assembly. Rule 227(1) of the NA rules states that the portfolio committees must maintain oversight of executive organs of state falling within its portfolio, may monitor, investigate, inquire into, and make recommendations concerning any such executive organ of state, including the legislative program of such organ of state, and may consult and liaise with any executive organ of state. Therefore, the committee has oversight powers over the department's legislative programs, as well as the initiation and preparation of legislation. In 2009, the Independent Panel Assessment of Parliament criticised Parliament for a poor record in introducing legislation. In response to such criticism, Parliament created a dedicated legislative drafting capacity within our office in 2013. Since then, 17 committee bills were developed, 12 of which have been passed by Parliament. It is, however, not always possible to develop a committee bill. The following factors would favour the continued monitoring of a proposed executive bill as opposed to developing a committee bill. If a bill requires policy development, if a bill is contentious, or if a bill requires subject matter expertise. The following factors favour the drafting of a committee bill. If the bill is likely technical in nature, with little or no policy development required, where the court provided a read-in that could be utilised, if the bill will deal with a non-contentious matter with little or no policy development required, or if the bill will only deal with issues and content affecting Parliament or provincial legislatures. The committee has the following constitutional powers relating to the development of a committee bill. Sections 43A and 44(1) of the Constitution state that the National Legislative Authority is vested in Parliament. Section 55(1)(b) provides that the National Assembly, in exercising its legislative power, may initiate or prepare legislation. So these are committee bills. Section 73(2) states that the committees of the NA may introduce committee bills in the NA. The 2009 independent panel I referred to earlier stated that the power of the NA, through its committees to initiate legislation, is a powerful tool to address policy issues and assert its independence. In terms of Parliament's draft strategic plan for 2024 to 2029, Parliament identified impactful lawmaking as one of its outcomes, by amongst others implementing measures to enhance the drafting capacity of Parliament. Committees are therefore empowered and encouraged to initiate and prepare legislation. This Lacuna project thus empowers committees to develop legislation by bringing matters to its attention which could result in the development of committee bills. The specific lacunae we identified will be discussed in detail in the next presentation. In the O'Brien matter, the Constitutional Court declared sections 15 and 17 of the Military Discipline Supplementary Measures Act and sections 101 and 102 of the Defence Act unconstitutional and invalid. In respect of Section 15 of the Military Discipline Supplementary Measures Act and Sections 101 and 102 of the Defence Act, the Court provided a remedy in the form of a reading down, in which the Court ruled on the matter the provisions must be interpreted until Parliament cures the invalidity through remedial legislation. A possible committee bill may therefore, in our view, be recommended in respect of these provisions. With regard to Section 17 of the Military Discipline Supplementary Measures Act, the Court did not provide a remedy, but indicated the manner in which the Minister may resolve the invalidity of the provision, pending the above-mentioned remedial legislation. The committee may therefore call upon the Minister to deal with the necessary policy development in respect of remedying the effect of this provision, by either bringing an executive bill or providing the necessary policy to be included in a committee bill. Should the Minister already have a draft policy on the concerns raised, such policy could be incorporated in a committee bill. We therefore recommend that the committee invites the Minister to address the committee on his views, to address the judgment and correct the defects, to request the Department to comment on the feasibility of the remedies provided by the Constitutional Court, to consider whether initiating and preparing a committee bill regarding some or all of the defects is a viable option, and if the committee decides to develop a committee bill, the committee can request permission from the House to introduce a committee bill that will correct the defects. If the committee decides on the development of a committee bill, it can send instructions to our office via email. Chairperson, with your permission, I will now hand over to my colleague, Mr. Sean van Bedar, to address you on the lacunae in the two acts. Thank you very much.
Mr. Sean, you can proceed.
Thank you, Chair. Good morning to the honorable members. Chair, may I share my screen?
Permission granted.
Thank you, Chair. Can you see my screen?
Yes, you can proceed.
Thank you, Chair. Chair, the purpose of this presentation is to discuss the impact of the Constitutional Court judgment of Lieutenant Colonel O'Brien versus the Minister of Defence and Military Veterans, and the impact of the judgment upon the Military Discipline Supplementary Measures Act of 1999 and upon the Defence Act of 2002. Chair, I will also discuss the options available to the committee to manage the correction of the defects identified by the Constitutional Court in the aforementioned statutes within the timeline set by the court. Chair, the case dealt with the independence of two military courts. Both courts are courts of first instance established under the Military Discipline Supplementary Measures Act, which I'll refer to as the MDSM Act. And the court of a military judge and the court of a senior military judge are the courts which the Constitutional Court referred to. Now, the applicant was a lieutenant colonel in the South African National Defence Force and a former military judge who challenged the constitutionality of sections 101 and 102 of the Defence Act and sections 15 and 17 of the MDSM Act. The applicant approached the Constitutional Court with 3 challenges against the provisions of the aforementioned statutes. Chair, first, in respect of sections 101 and 102 of the Defence Act, whether it is constitutionally permissible for members of the executive to have the power to initiate and control boards of inquiry to investigate judicial officers' fitness and the conduct of their cases which occurred in the applicant's case. And second, whether the power under Section 15 of the MDSM Act permitting the Minister and the Adjutant General to make renewable assignments of military judges for short periods at their sole discretion and without any objective criteria, whether that passes constitutional muster. And third, relating to the constitutionality of Section 17 of the MDSM Act, which empowers members of the executive to remove military judges for alleged misconduct or incapacity without the involvement or oversight of any independent body. Now, Chair, it should be noted that the Minister and the other respondents in the matter contended that military courts are not courts as contemplated in the Constitution. They further contended that military judges are not judicial officers as envisaged in the Constitution. The court disagreed and held that military courts are indeed courts as contemplated in Section 166, paragraph E of the Constitution, and that military judges are indeed judicial officers as contemplated in Section 174 of the Constitution, and that they therefore enjoy judicial independence as guaranteed in the Constitution. With regards to the court's judgment, Chair, and the challenge against sections 101 and 102 of the Defence Act, the Constitutional Court found both sections to be unconstitutional and therefore invalid. The court reasoned that under the Constitution, it is not permissible for the executive to have the power to initiate and control boards of inquiry, to investigate judicial officers' fitness and the conduct of their cases, as it occurred in the O'Brien case, and that this offends the separation of powers doctrine and infringes upon the independence of the judiciary. Regarding Section 15 of the MDSM Act, the court held that non-renewable terms for judges is an essential prerequisite of structural independence, and that it is unconstitutional that military judges are the only full-time judicial officers who are appointed for short renewable terms, notwithstanding the significant geographical and penal jurisdiction. The court therefore declared Section 15 of the MDSM Act unconstitutional and invalid to the extent that it does not provide adequate security of tenure for a military judge. Chair, with regards to the challenge against Section 17 of the MDSM Act, the court held that it is unconstitutional for the executive to have the power to remove a military judge without independent oversight or control. Section 17 of the MDSM Act was therefore declared unconstitutional. The court declared that all the challenged provisions of both the Defence Act and the MDSM Act unconstitutional and invalid, but did provide certain remedies. Now, in respect of sections 101 and 102 of the Defence Act, the court agreed with the applicant's suggested approach to remedy the constitutional defect through a reading down of the impugned provisions, which entails the reading of the phrases "any matter, any member or employee, and the affairs of any institution" in sections 101 and 102 of the Defence Act as excluding military judges. And in respect of Section 15 of the MDSM Act, the court held that pending the coming into operation of remedial legislation, the assignment of a military judge may not be renewed until the lapse of at least 2 years since that person's last assignment. In respect of Section 17 of the MDSM Act, the court held that it was not possible to remedy the constitutional defect through a reading down of the impugned provision, and the appropriate remedy was to suspend the declaration of unconstitutionality for a period of 2 years. And pending the coming into operation of remedial legislation, the court held that the minister may devise processes for an inquiry into the fitness of a military judge and the composition of the inquiry body, provided that it is an independent inquiry and a military judge may not be removed except on the recommendation of the independent inquiry. Chair, the Constitutional Court's declarations of invalidity in respect of Sections 101 and 102 of the Defence Act and Sections 15 and 17 of the MDSM Act was suspended by the court for a period of 24 months. Now, that is to allow Parliament to cure the constitutional defects in those provisions through remedial legislation. Now, the suspensive order will lapse on 20 December 2026, and the required remedial bill must therefore be passed by Parliament and assented to by the President by the 19th of December 2026. And as discussed, Chair, the court provided a temporary remedy for Sections 101 and 102 of the Defence Act, as well as for Section 15 of the MDSM Act, by means of a reading down. However, the remedies will lapse on the 20th of December 2026. And as discussed in the previous presentation, a committee bill may therefore be proposed to remedy those provisions. Now, as indicated earlier, Chair, the court did provide a remedy in respect of Section 17 of the MDSM Act. Sorry, did not provide the remedy in respect of Section 17 of the MDS Act, but indicated the manner in which the minister may resolve the invalidity of the provision. The remedy of the defect in Section 17 of the MDSM Act will therefore require the department to develop policy, and the committee may therefore call upon the minister to deal with the necessary policy development by either bringing an executive bill or providing the necessary policy to be included in a committee bill. It is therefore the committee's prerogative to either have the constitutional defects in the impugned provisions corrected by means of a committee bill, or to call upon the minister to introduce an executive bill to cure the defects. And should the committee opt for an executive bill to cure the defects, the committee may then regularly review the progress made by the department. However, considering the impending suspension of the court's order, we recommend that the committee should make its decision by August, which is next month. Thank you, Chair. That is the end of this presentation.
Thank you very much, Mr. Sean. I would request that we also acknowledge the Deputy Minister, retired Major General Bantu Olomisa. I saw him. I would request that we move to the next item before we allow members to ask questions on the way forward. I would allow the Minister, Honorable Motshekga, to reply to what is proposed by the Parliamentary Legal Services on the way forward, and probably allow the department to do their presentation in terms of how we can conclude the amendment of the legislation to be in compliance with the Constitutional Court order which saw some constitutional defects on the legislation that we had, but at least it does not give us the whole nullification of the act, but it's specific on sections that we need to look at as part of the way forward. My only concern when the department replies is to give us proper timelines and proper deadlines, because between now and January, since the court decided in December last year, we have lost 7 months to 8 months, either to have brought a motion and developed a process plan, but the department will answer to some of these things. I'll give over now to Honorable Angie Motshekga, our Minister of Defense and Military Veterans. Over to you, Minister.
No, thank you very much, Chair. With your permission, let me also switch off my video. I just wanted to greet yourself and members of the committee, officials from both DOD and also from Parliament.
Permission granted.
Thank you, Chair. Chair, thank you very much for the opportunity again to come and present ourselves before the committee. I can confirm, Chair, that more than on 2 occasions we did discuss the bill, because it's quite clear the directive. So it's actually a straightforward process which really has to do with how we implement. And as the presenter had said, there were 2 approaches also that were proposed, and we had to agree whether we bring a new bill or we make amendments. And you'll see from the report what we really have put. So Chair will present the report and say we have started the process to discuss even before he invited us in here. And we will also give you what we thought would be a way forward, because indeed we're all also, because we're counting days to say this decision was made almost more than 7 months back. And we had only started discussing, or from our side, monitoring the progress from June, which would have been 6 months before the time, and estimated that we are only left with about 14 months before the end of the time frames, and therefore have to finalize our processes. So, Chair, I don't want to take over what is in the submission, but accept that we indeed we have been discussing the matter, looking at the matter, and saying how we're going to proceed with it, and what other alternatives that we have. We acknowledge that in terms of responding, we're supposed to have started responding by December last year, so that we will not have lost the 6 months, but that is the reality. But we were then talking about how we claw back the lost time for us to meet the deadline as established and as set out by the court. So we just were really looking at how we implemented the time before us and what is it that we need to do in between. So, Chair, let me not take the time. The Deputy Minister Holomisa is abroad. I'm not sure if he's joined, and the Deputy Minister Mkungi is also in another portfolio for housing. So I'm bringing their apologies. They're both unable to attend. So with your permission, Chair.
To assess the situation, he said we'll call a commission of inquiry to do what? To investigate libel. So this commission.
Oh, I see General is here. So which means he's joined he has joined. So Chair, let me allow if through your permission, ask the team from the Secretary's office, because it's a joint function between the uniform side and the Secretariat, to present what we've been discussing and what we propose as a process and the timeframes for us to be able to fit in within the time that we have been given, so that we don't miss the deadline which has been established for us. But I must say I'm opportunistic, Chair. I also saw that the Parliamentary Committee is talking about the 25th of August, and I already want to pen it in as another date that you want to give us, to give you some concrete work emanating from our discussions, because at this stage, we were still at a discussion process more than concretely doing the work, so that we can bring before you to say, these are the concrete steps we've put in place to be able to deal with the court process. So, Chair, through you, can I hand over to Dr. Mnisi on behalf of the department to inform the cabinet on what having our discussions and what our plans are and what we want to request from the committee as a way forward pending in the 25th of August, which have been proposed by the legal team. Thank you, Chair.
Thank you very much, Honorable Minister. I'm sure your team, the 25th of August is for us as the Portfolio Committee to decide whether we go the executive route or the committee route.
Okay, accept. Okay, Chair.
Yeah, we'll only.
That's why I say I was opportunistic. I was opportunistic. Let me withdraw.
So if the executive is not ready with the draft or any way forward by August, we are going to take over as the committee to proceed with the Parliamentary Legal Services so that we are not in contempt of the Concord Order.
No, I say I withdraw the opportunistic.
No, thank you. Over to you, Doctor. Who's presenting from the department?
Sector is Miss here. Oh, Miss.
Over to you, department.
General News. Hey.
Then the committee will have to take over if the department is not coming.
I'm surprised because Sector was missing, or even but
no,
I mean, came out. I don't know where the team is.
Okay, can you?
Okay.
Good morning, Minister. I'm sitting with General Minister. Good morning, Minister and Deputy Ministers and members of the committee. I am sitting with General Mnisi, who is the Adjutant General in the department, and I'm sitting also with General Mantuane, the Chief of Staff, and I'll straight hand over to General Mnisi to take the committee through. Thank you. Thank you. Maybe you continue.
Good morning, Minister, Chair, and members of the Portfolio Committee on Defense. I'm Major General Mnisi, the Adjutant General. I've been tasked to come and present what has happened with the bill since what has happened since the Constitutional Court decision. My aim is to brief the PCD on the progress made by the Department of Defense on legislative amendments after the Constitutional Court decision on the O'Brien matter. My brief scope, Chair, is what happens. And you will see at the second last are the timelines. Chair, my colleagues from Oxley have broadly presented the genesis of this case, of this matter. But as a matter of background, I would say a decade ago, military judges whose assignments were about to expire were not appointed for a period that was more than 15 months. Lieutenant Colonel O'Brien was one of those military judges. In one of the cases he presided when he ultimately was appointed as a military judge, he issued some orders, among other things, where he instructed the President of the Republic of South Africa to take disciplinary actions against the then Minister of Defense and military veterans. He also issued orders to the then Minister of Defense and military veterans to take disciplinary actions against certain seniors or officials of the Department of Defense. The then Adjutant General instituted a board of inquiry, and my colleagues have definitely dealt with the challenges of this board. He issued a board of inquiry in terms of Section 101 and 2 of the Defence Act, to investigate the conduct of the member, meaning the judge. And my colleagues have stressed, Chair, that once the colonel issued these orders, he was sitting as a military judge. The board commenced its duties. That is how it happened. And then in 2017 March, the current Adjutant General, meaning myself, I assumed office in acting capacity until the 31st of May, where I was appointed in June. Then the Adjutant General, I was of the view that the Board of Inquiry was not a proper instrument to investigate any misconduct of a military judge emanating from the bench. I want to underscore that, Chair, I was of the view that a Board of Inquiry is an administrative tool. It cannot investigate a judicial tool, a judicial decision. Then the issue now was, how do I undo the Board of Inquiry and all these things? Then, and how, at the end of the day, how do I respond to the orders of the judge? One was to ignore those orders. No, you cannot ignore orders of the court, even if you disagree. I then approached the High Court to review and set aside the orders made by Lieutenant Colonel O'Brien. And it is very important to say that once Lieutenant Colonel O'Brien made those orders, neither the minister nor those senior officials of the Defence Force were called as witnesses or accused in the court of law. Hence, I definitely approached the High Court for relief. Then both the High Court and the Supreme Court of Appeal decided in favor of the Department of Defence in that regard. Then O'Brien approached the Constitutional Court, claiming executive interference and unconstitutionality of certain sections of the DSMA and the Defence Act, as my colleague from Oxley have alluded to. I'm not going to go in depth on those things, on that, Chair. Now, the Constitutional Court. The Constitutional Court declared unconstitutional certain sections of the DSMA and the Defence Act, as alluded to by my colleague. The court ordered the minister to amend those particular sections, especially 101 and 102, to exclude military judges from the risk of being investigated using the Board of Inquiry. Actually, the Constitutional Court said exactly what we said, that no, Board of Inquiry was not the right tool. Then it also said the appointment of military judges for a period of less than 3 years was unconstitutional. Remember, military judges are members of the Defence Force who also aspire to progress with their careers. After 2 years, maybe somebody gets promoted and is assigned on something else. But the court said no, a period of less than 3 years is unconstitutional. Then that the appointment of military judges by the minister on the recommendations of the Adjutant General was also found to be unconstitutional. That those members who have been assigned, means if, let's say, for instance, person A has been assigned as a military judge and his assignment expires today, 2025, then he cannot be reassigned within 3 years after the expiry of that assignment, meaning it's a cool-off period in our interpretation, Chair. Then the minister was given 24 months to amend legislation to give effect to the Constitutional Court's decision, and that ends on the 19th. Then on the 20th, we have to go and report. That's the Constitutional Court issue, and we agree of what other colleagues said about the judgment, the details, Chair. Now, what has been done up until today? Then, Chair, those consequential amendments, before we go that, the committee will recall that the defense, the DOD, had dealt with the MDB, Military Disciplinary Bill, meaning repealing the entire Military Discipline Supplementary Measures Act. So now those consequential amendments had to be dealt with. Then we established, firstly, we definitely dealt with them in MDB. And then in the MDB, there is a clause which establishment of the Military Judicial Committee or Commission to advise the minister with the appointment and the misconduct of military judges, so that they are not dealt with in terms of Section 101 and 102 of the Defense Act. Military judges, again, we say in those clause, amended clause, military judges may not be appointed for a period of less than 3 years, meaning the minimum is 3 years, is 3 years. We effected that, that on the bill. That the investigation of misconduct by military judges committed while performing their judicial functions shall be conducted only in terms of legislation, that legislation when it's promulgated, meaning on the recommendations and the investigation by the Military Judicial Committee or the Military Judicial Commission, as provided in the bill, Chair. We continue that the period of 3 years must pass before a member is reassigned to the bench. If a member was assigned and then he's, let's say for 5 years ends, then he must wait for another 3 years before he put that. And then here, Chair, we want to bring this into your staff. We effected that, but we are obligated also to put forward the problems, the challenges. This is a problematic because the capacity and the career progression of military judges. Otherwise, we are not a big organization, or Defense Legal Services is not a big organization, and the pool of military judges will shrink. Now, if we put military judges for 10 years, it means that progression in rank and other exposures will be limited. But Minister and Chair, we have complied with that. The MTP was tabled, was supposed to be tabled before, it was in the agenda of the COD on the 4th of July 2025 to brief the minister so that we follow external consultation process. The DOD has effected the legislative amendments. Before we go that, Minister, and you'll recall that because of the other issues, the agenda of the COD, you postponed that and you said you will call us as soon as possible, so that we can table that. Then the DOD has effected the legislative amendments in accordance with the Constitutional Court. The legislative process is to be followed in terms of slide 13. I'll go to slide 13. Way forward. Now, on the 14th of July, it was decided by the leadership of the department that the amendment must be done on the Military Discipline Supplementary Measures Measures Act 16 of 1999, meaning we put aside the amendments that we have done on the Military Disciplinary Bill. Then that has been done, Chair. Then the amendment of both Section 101 and 2 of the Defense Act with regard to the Board of Inquiry, investigation, that has already been done. Now, what is supposed to be done is legislative process, and we'll allude to that when we go to the time frames. Then critical success factor, Chair, and as officials, we are aware that the time is against, is not on our side. Then we will, as a critical success factor, need support from all stakeholders. Chair and the Minister, please allow me to put forward to present the proposed timelines. Effecting legislative amendments on both Military Discipline Supplementary Measures Act and the Defense Act are finalized. Then we will present this thing. I mean, for process purposes, the PDSC, Plenary Defense Staff Council, next week will present. Then, Minister, I was instructed by my principals here that I must present this to the COD on the 25th, because only the minister must now tell us go out for external consultation. Then on the 25th of July, we have to present to them to the COD. Then on the same, immediately that if it is adopted, then we will approach, OXLA, the Office of State Law Advisors, for pre-certification. Now that pre-certification, Minister, it will deal with two clauses, one clause or two clauses in the Military Discipline Supplementary Measures Act, and one clause, two clauses on the Defense Act, and also on the on the definition. Then after we have received the pre-certificate, we will in August go to DEFCON for external consultations. Then once we're doing that, then we'll be also follow the socio-economic impact assessment in October. Then once we have received that certificate, Minister, we will present this thing in November to the ministerial committee to clear it for cabinet in January and table this in Parliament, and the minister table this in Parliament in February 2026. Minister and the Chair, thank you very much for giving us the opportunity to come and present what has been done since the court decision. I submit.
Thank you very much, General, for the presentation. We will now allow members of the Portfolio Committee to ask questions. But just to highlight to the department, the General, is that as the Portfolio Committee, we are the authority that it's responsible for lawmaking. So when the court has concluded that we have 24 months to bring back a solid constitutional compatible legislation, it's our responsibility as lawmakers. Now, when you as a department sit for 6 months without bringing a motion or drafts on amendments as instructed by the court or directed by the court, you are putting us in trouble as the Portfolio Committee, either by ineptness or your timidity. So we have lost 6 months of production in terms of complying with the court. I see your deadlines at least brings a relief, but still, it does not take us out of a possible contempt of court order. And unfortunately, it's not the SecDef, it's not the General who will be in contempt of the court order. It's us as lawmakers in this Portfolio Committee. So it's our humble request that whatever you conclude as a process plan, please ensure that you comply with it, because in our case, in terms of National Assembly rules, any contempt or misleading of Parliament, it's a serious offense. And for me, as a public office bearer, it can lead to my dismissal. It's unlike a case where you are allowed to make mistakes and you are protected by labor law. In our case, we're not protected by labor law. I get dismissed for misleading Parliament. So whatever you've presented here, it's what I take in record. And if it's not implemented, it means as the chair, I would have misled Parliament. Members of this committee can take me to the Ethics Committee or even can open a criminal case of perjury against me for failing to comply with the court. That's how serious this business is of running a legislative process. So it will be our humble request that you comply with that. But let me give over to the members of the Portfolio Committee to raise whatever they they would like to raise as questions to their department and to the Parliamentary Legal Services. But from my side, I would also want the Parliamentary Legal Services to tell us, given the remaining 14 months, is it possible for us to comply through an executive bill, or what is the simpler way between an executive bill and a committee bill to comply with the Concord order? Because I'm afraid, I suspect we are being compromised. 6 months has passed with no motion or process plan, and how do we trust with the remaining 14 months? I would want the Parliamentary Legal Services to advise us so that we are not found in contempt of the court order, especially of the Concord order, which is the apex court of the land. Over to you, members.
Chair, we should start.
Okay, I see the Honorable Niehaus, Honorable Harten, Honorable Khwekane in that order for now.
Thank you, Chair. Chair, let me amplify what you've just said about the dereliction of the department, because once again, quite in character of the way in which this department is not able to carry out its duties properly, they have allowed 6 months to expire. That's my first concern, and that puts us under unnecessary pressure, as you have already said. Secondly, Chair, let me raise my concern that once again, the presentation that we have received from the department and the final presentation that was delivered to us today included additional slides that were not part of the presentation that we received, and a very significant and important slide which were about timeframes. When I look at those timeframes, Chair, they do not tally with what I think you were quite correct to say, that we need to take a decision by the 25th of August. The timeframes presented to us overrun that date of the 25th of August by the Department of Defense and Military Veterans. So this is unacceptable, Chair, and once again, I must note my dismay that the department keeps on changing presentations that they bring to us, and this must come to an end. As far as the amendments that are proposed by the Constitutional Court, which you quite correctly state is the apex court of the country, are concerned, it is not for us or for the department to question the rulings of the apex court. It is for us to implement. So some of the comments that the department made about consequences of the ruling, we can take note of, but they are indeed irrelevant for the decisions that we need to implement as passed on to us by the apex court. From what I can see, Chair, it would be advisable for the bill to be finally produced by the executive and then to be piloted through Parliament under, unfortunately, the pressures that we are faced with now because we've lost 6 months. However, Chair, if the department continues to behave in the derelict manner that it does as usual, and it fails to meet a commitment to us on the 25th of August, and I think that date you should underline and make a firm date, we as the committee have to take over. And under those circumstances, we will have to introduce a committee bill in order to be able to make sure that within the next 14 months, we can comply. So by the 25th of August, it is a hard deadline. Either the department tells us they're going to do the executive route and they give us enough comfort that they are going to be able to comply with it, and the legal services of Parliament advises us that it is possible within the time frame that remains that executive bill can then be piloted through Parliament and can become legislation, the amendments that are required, so that we can meet and comply with the instructions that we have received from the Constitutional Court. But I want you and our committee to rule and make a clear undertaking here to the Department of Defense that if we do not get that comfort by the 25th of August, that we will be duty bound, as you quite correctly said, Chair, as the Portfolio Committee on Defence and Military Veterans and as members of Parliament, we are under particularly strict rules and regulations in terms of our position as members of Parliament to comply by the law, that we will then introduce a committee bill. I think that is it, Chair. The basics of the amendments that are required are clear, and the understanding of what the Constitutional Court has said to us is clear. I must say that I find the rulings of the Constitutional Court in this particular instance apt and correct, but even if we had any disagreement about it, that would have been just academic. Ultimately, this is the apex court, and we have to follow what the court instructs us to do. Thank you, Chair.
Honorable Harte.
Thank you, Chair. Starting off, I would agree with you that the Parliamentary Legal Services perhaps come into it after the department have responded to the two presentations. I would like then support you that Mr. Sean van Breda perhaps comment on what was presented to us by the Department of Defence. Chair, I've got a concern. It appears that the department from a presentation is not really very happy with the Constitutional Court, and that there's a grudgingly an acceptance of the Constitutional Court rather than a genuine embrace of what is actually behind the Constitutional Court's order, and that is to protect the independence of military judges from executive interference. That has not been explicitly addressed. And the way the Department of Defense actually presented their opinion is actually that it appears that there are some of the Constitutional Court's order is actually seen as an obstacle to operational flexibility and not a necessary correction to make the whole process, military judiciary process, constitutional. So I've got a concern about the whole tone of the Department of Defense presentation. So, Chair, and then coming to the time issue, if you look at the time in the slide, 2 days ago on Monday, suddenly after 7 months, after the 20th of December 2024, suddenly there's some action. And that would not have happened, Chair, if you didn't call this meeting and didn't get the Department of Defense to come and report on it. And that is why also we then got the late amended presentation from the Department of Defense. These are not positive signs coming from the Department of Defense, Chair. I know it's very difficult to get a judgment, Constitutional Court judgments against the department, and then also being hit with cost orders against the Minister of Defense. So, Chair, those are my concerns. Perhaps before I put any further questions or any, I would like to get a brief response from Mr. Sean van Breda on the Department of Defense presentation. I thank you.
Thank you very much, Honorable Hatting. Before I bring in Mr. Sean Breda, let me complete the list and then get to Mr. Sean Breda. Mr. Breda, you can prepare yourself to advise
Please
us.
note me as well, Honorable Chair.
Hello?
My sincere apology. Please note me for questions, Honorable Chair.
Oh, no problem. You are welcome, Honorable Diale. Honorable Fekane, followed by Honorable Hala and Honorable Diale.
Yes, thank you very much, Honorable Chair. I'll just go straight to the questions.
Okay.
Honorable Chair, what I want to know, why has the Parliament not yet initiated committee bills to address the Constitutional Court's declared defects, especially a given agency of the O'Brien ruling? My second question, has the department formally presented any draft executive bills to remedy this lacune? And if not, why? What interim legal uncertainties persist in military discipline cases while these legislative gaps remain? Fourth question, how does the department ensure constitutional rights of military members are protected under defective legislation still in force? What technical or political obstacles are preventing drafting of the committee bills to close these gaps? Why was there such significant delay in identifying these legislative defects, given Parliament's oversight mandate? And how is Parliament assessing potential risk of legal challenges arising from ongoing application of unconstitutional provisions? Is their CLSO sufficiently resourced to help this committee initiate legislation rather than waiting for executive bills? On the amendments of MDSMA, Honorable Chair, I have some few questions. My first question is, why has it taken until now for the department to bring forward legislative amendments after the 2024 Constitutional Court ruling? How is the department managing ongoing military justice cases while the legislation remains unconstitutional? What is the department's plan to mitigate shortages of qualified military judges given the 3 years reappointment restriction? And why was there no contingency plan for legislative reform sooner, given known legal risk from the O'Brien litigation history? Has the department conducted a risk assessment of potential court challenges to current proceedings under unconstitutional laws? How does the department reconcile career progression concerns with the Constitutional Court's directives? What resources have been allocated to ensure the legislative amendments are finalized before the 2026 deadline? Lastly, Chair, why has the military discipline bill not yet been fully processed despite being on the Council on Defense agenda as of July 2025? That's my submission. Honorable Chair. Thank you.
Thank you very much. Questions noted. Can we move to Honorable Hala?
Good morning, Chair. Good morning, Minister. Good morning, honorable members. Chair, mine is just on is with General Mnisi on his first priorities. The amendments done on MTSMA 16 of 1999 and the amended section 101 of the Defense Act. Is there a possibility for them to hand over those documents to us so that we see that indeed these amendments were done? Thank you, Chair.
Thank you, Honorable Hala. Honorable Diale.
Thank you, Chair. I must confirm I'm extensively covered by my colleagues. The main question that I wanted to check was on slide 12, the department is mentioning that the legislative amendment is finalized. I just wanted to check with them, what does it mean finalized? What have they done to finalize with what do they have? Tangible documents that they have to show that they've actually finalized the process of legislative amendment. I'm just worried on the same slide or the next slide, Chair, they've mentioned that they're going to be, that's the second question. On the slide 12, they've mentioned that they're going to be doing presentation to PDSC. Now, on that particular point, they mentioned in July 2025. What is the exact date of presentation? Have they agreed or have they arranged properly with PDSC for the presentation? And what is the exact date? I guess we are in the middle of July already. By now, they should be knowing. If it's true, they should be knowing by now when are they exactly going to be meeting or to be doing the presentation as indicated. Some of the questions are, the other part was the presenter, Honorable Ntatemunis, when he presented, he said the deadline as indicated by the court order was the 19th of December 2026, meaning, and then he said on the 20th of December 2026, we will then be going to report. Now, clearly, it shows that they have not been, the dates that are indicated there that they'll be processing that are before the 20th means it's not true. That it was just an afterthought. Hence, we have new slides that were added like this morning or last night as an afterthought to the committee. So they must indicate to us exactly what does finalized mean. What have they done? What do they have? Do they have legislative provisions with them that have been amended, and what process have been done towards finalizing those amendments? Thank you, Chair.
Thank you very much, Honorable Diale. What I will do now, before I come up with the way forward, I will allow Mr. Sean van Breda to give us the advice from the Parliamentary Legal Services, then allow Honorable Harding, as per his request, that he has follow-up questions after Mr. van Breda has addressed the Portfolio Committee. Over to you, Mr. van Breda and the team from Parliament.
Thank you, Chairperson. Just with regard to the timelines proposed by the department, Chair, it wouldn't be preferable for the bill to be introduced in February next year. But, Chair, it's not impossible for Parliament to process the bill within that period before the deadline. There are examples in Parliament where Parliament has processed bills in short periods of time. But, Chair, the concern is that places a lot of pressure upon the Portfolio Committee to process the bill timeously. And we must bear in mind that there must also be calls for public comments, and that could be time consuming. And once processed by the Portfolio Committee, the bill would then have to be processed by the relevant NCOP committee. However, this would be a Section 75 bill, which would mean that the NCOP would have a lesser role However, introducing an executive bill in February is not ideal. And obviously, there would be a considerable pressure upon the committees and upon the resources to actually for that bill to be processed in time. In addition, Chair, a further concern is that should the bill be passed by Parliament, there's also the next step of the President having to assent to that bill, for that bill then to become an act of Parliament. So that would also possibly be time consuming, and all of that needs to be done before the order of the courts is suspended, which is upon the 20th of December 2026. So, like I said, Chair, it is not impossible for an executive bill to be processed in that time period, but it is not preferable at all. That's all from me, Chair. Thank you.
Thank you very much.
May I request just an opportunity to respond to the question on committee bills? My name is Charmaine van der Merwe. I'm with Legal Services.
You are more than welcome. We want the whole team to say something.
Thank you very much, Chair. I would just like to respond to the questions on committee bills and the risks that Parliament faces in respect of especially constitutional court judgments, but I think gaps in our legislation in general. And I just want to confirm to the committee that as per Ms. Williams's presentation, and the committee can definitely go and look at her slides again, because she does give a little bit of stats that might give you even more confidence in what we can do for you. We do have a legislative drafting unit. We've got 6 drafters and a senior drafter, myself. So we've got 7 drafters. When we do a committee bill, we allocate 2 team members because a committee bill is not something that can wait for someone who might be off sick or something like that. And you also want 2 pairs of eyes at least on the whole process throughout the committee bill process. So we do regard it as a very, very important task for our team to participate in, and we definitely have the necessary staff to assist the committee should you decide to do a committee bill. But I just want to give the committee also some reassurance that in respect of this specific matter, this matter of O'Brien, our office have been liaising both with the committee as well as with the department, and we have been reporting in the National Assembly Programming Committee, because of course once this bill comes, this becomes a programming issue, and there needs to be plans put in place to make sure that the committee can process the bill in time, whether as a committee bill or as an executive bill. So we have reported on this. We've provided the original opinion to this committee in February, and then we followed up with the department directly, and the department has been responsive. I would like to just put that on the table so the committee knows that the department has been doing something. They have written back to us in April. We asked them what is the progress on this matter in March, what are they planning to do? And in April, they wrote back and they indicated to us that they are seeking legal advice in order to see what they can do in their legislation in order to address this judgment. They also asked for some guidance, and we then wrote back and in fact, I provided my email address and invited them to contact me should they want some advice on the legislative process. But then we have this project to promote committee bills, and we also thought that it was necessary for the committee to be made aware that time is starting to run, and that is then why we ended up with this presentation to you, to stress the need for some plan at least to be in place. If we have a plan and we know we are expecting a bill in February, we can start looking at how do we program and will we make it. And as Mr. van Breda has indicated, it is likely to be a Section 75 bill. And that will mean that your process in the NCOP is not so protracted, because with the 76 bill that affects provinces, there's consultations in the provinces, there's negotiating mandates, final mandates, and that process is at least 8 weeks. So you could have a shorter period in the NCOP, which does assist for us to get this bill through by December. But we also need to keep in mind, there's a normal program of the committee. So I just wanted to assure the committee that our office is we do have our finger on the pulse, but there is a lot of work, of course, before committees, and we are also cognizant of that. We are reporting to the NAPC, so the risk is being attended to. But of course, a risk being attended to doesn't mean the time isn't running. So that is where we're at. Thank you very much.
Thank you very much, Parliamentary Legal Services. I would go back to Honorable Harting. I saw also there's a hand of Honorable Niaus. Over to you, Honorable Harting.
Thank you, Chair, and then also thank you to Mr. Famara and Ms. van der Merwe for the input. Chair, I've got no further questions. I would like to put then on the table the following proposal, that we take a decision on next week, Wednesday, on the 23rd, on which one of the two paths should we follow, the departmental path or the committee path for the introduction of the amendment bill. And I'm saying that because I believe that the department has, and the minister has heard the opinions here, and that they be given a fair chance to revisit their proposed path forward. Because what has been put forward to us in their presentation, I've got serious doubts in my mind whether that will fly. Also taking into consideration that, like I've said, the reluctance of accepting the apparent reluctance of accepting the Constitutional Court order. So I would suggest that we consider the way forward next week, Wednesday, giving then the department 6 days to submit a revisited proposal to us. I thank you, Chair.
Thank you very much, Honorable Niaus.
Thank you, Chair. Yeah, overall, I absolutely agree that it's really irrelevant what the department's attitude to the Constitutional Court's ruling is. They must comply. As far as the proposal of Mr. Hutton is concerned, that we consider next Wednesday the response of the department, I think that's even better than the 25th of August because it moves us faster forward. If we come to the conclusion that we are going to do this as a committee bill, then obviously we've got our work cut out. If the department comes with an alternative proposal, they will have to convince us whether they are going to comply, as Mr. Hutton said, especially in the context of their apparent reluctance to accept the ruling of the Constitutional Court. What I would like to hear from Mr. van Breda is what would be an ideal period for this legislation to be ready and to be tabled. He said it can be done if it is done in February, but it is not ideal. Can we get an ideal time frame, and let us then, as a committee, see if it is possible to meet that time frame, and also judge next week on Wednesday, if the department says to us they want to present it as an executive bill, whether they will indeed be able to meet that ideal time frame. I think it's unacceptable, Chair, that we place everyone, the department places everyone, including ourselves as a committee, under time pressure because of their dereliction. And next week, we must bring an end to this nonsense. Thank you, Chair.
Thank you very much, honorable members and the presenters from both the department and the Parliamentary Legal Services. There is no doubt, honorable members, about the type of the system we have, or the state governance we have, which has got three arms. of the executive, the judiciary, and the legislature. Now, as a constitutional, we're not under military dictatorship, so there's no way that the National Defense Force or National Defense Department can impose itself over the system of our democracy that we've chosen. So the court order, it stands. We need to comply. And fortunately, in our case, the court order is not saying we nullify the act. The court order is specific that review Section 101, Section 102 in this act, review Section 15 and 17 in this act. And I mean, it's not supposed to be very difficult to amend what the court has directed us to do, because we're not the only department or the only point, the only department or the only institution to face such orders from the apex court of the land. Because failure from our side to comply with the court order is going to lead to criminality. And that's what I'm not ready for from my side. As the chair and equally the portfolio committee, I know the spirit of how we run this committee. We will not want to be the ones who are undermining the rule of law, especially when we've taken an oath to defend the Republic, its people, its territory, its sovereignty, its constitution, and all international laws. So if you are upholding the international law and the rule of law, there's no way that you can refuse or be insolent to implement the court order. So that is going to be done. I think I must allow the Parliamentary Legal Services to advise, as asked by Honorable Niehaus. Then from there, I'll come up with the way forward.
Thank you, Chairperson. May I respond?
So on the proposal made by Honorable Atin. Over to you, Honorable. Mr. Fadreda.
Chair, there's a sound problem on your side.
Yes.
We can't hear you. You're breaking up.
All right, Parliamentary Legal Services, over to you.
Challenges that arise from the
Thank you, Chairperson. You were breaking up a little bit, but I will just respond to the proposal. Chair, as I said, that the proposed time frame from the department is not it's not ideal, but it's not impossible. A more realistic time frame would be for the bill to be tabled in December this year. That would take a lot of pressure off the support staff of the committees and would then allow for the calling of public comments in that period. So in our view, that would be more realistic than introducing in February. But as I said, not ideal, but it's not impossible. Thank you, Chair.
Thank you. Am I audible?
You're audible now, Chair.
Okay, thank you very much. I think as part of the way forward, we have to conclude that we will allow the department to review its timelines. Also, the department to come back to us next week on the review timelines and the process plan towards the bill. Failure for the department to comply by next week, Wednesday, we will be left with no option but to go the route of the committee bill. We also direct the department to consult with Parliamentary Legal Services in developing that process plan, in looking at those amendments, and where possible, the draft also can be brought forward so that we can get progress related to the amendments of these sections, so that we comply with the Concord order before the 20th of December in 2026. So if Parliamentary Legal Services says the ideal period for us to table the bill for public comments and scrutiny is December, let us try to find within our processes to go that route. But also the Parliamentary Legal Services would request that also by next week, Wednesday, you give us an opinion in terms of the best way of dealing with these particular amendments, whether should we take the executive bill route or the committee bill route, given that we are only left with 40 months without a motion, without a draft, without a process plan. Fastest way to ensure that we comply with the Concord order, but at the same time, we do a quality work, whether to go the executive bill or the committee bills. So by next week, also give us that particular opinion so that we are properly and clarified and guided, because I'm afraid to be in contempt of the court order, because in my case, in terms of the National Assembly rules, it's a dismissible offense. So I don't want to mislead Parliament and end up with no bread for my kids. I would want to do the work because I know ineptness and timidity can unintentionally lead to sabotage. For instance, in our case, we have the criminal element dominating both the executive and the legislature in South Africa, where we are unlikely to become, or unintentionally, to become a mafia state under our watch just by being timid and inept. And I'm afraid of that particular posture, especially from government, especially from the National Defense Force, which is military officers and not civilians. They must be meticulous and clear in application of the rule and the system, because they are the last line of defense, and they can't be the first line of disrespecting the rule of law. So what the Concord has ordered us to do, we need to comply with it. I think this brings us to a way forward. The rest will be decided after we've received the report in the next 7 days. But I must take this opportunity to thank the department, to thank the minister and the team, and also thank the Parliamentary Legal Services for the good work and the advices. We would still want an opinion from your side, whether to go executive or whether to go committee bill, whatever situation. We want a win-win situation for the department, and also to ensure that we uphold, respect the rule of law and the Constitution. So the Concord as the apex court, its order stands until we have amended the Act. Thank you very much. You are released. All right, anything? Okay.
Chair, sorry, it's Valaram van Rensburg. Chair, members, I just noticed, I quickly checked the program for next week. Next week, Wednesday, there's a plenary sitting from 10 in the morning around the appropriations bill, the consideration of the appropriations bill. However, the Thursday, the following day, is set aside for committees. So if it pleases yourself and the committee, perhaps we can stick with the deadlines that you provided to the department and legal services around Wednesday, but that we schedule the actual meeting for next week, Thursday on the 24th, just to avoid a clash with the plenary sitting.
No problem. No problem. I fully agree, because if it's appropriations on Wednesday, it means we are voting for the budget. So all parties would want their members to be in their caucuses for mandates, and also there's a 3-line whip. We can't have any other meeting except that plenary. So it's agreed. So Thursday, look at the appropriate. We can look at Thursday, 10 o'clock. Are members available?
Sorry, yes, Chair, if you can check the availability of members, because Thursday morning is normally caucus day.
Oh, yes. Oh, Thursday morning. Okay. Members will tell us when are they available in the portfolio committee group, whether they are available for If their caucus is at 10, obviously we'll have to shift our meeting to 2 o'clock. It can still be virtual because it's just to get the feedback and to get to know what is the way forward in terms of ensuring that we comply with the Concord order, because any other way would mean that we are in contempt of the court, and it will not be a general or a SecDef. It will be us as the portfolio committee, which is has the responsibility of lawmaking, that would have not complied with the court. Thank you. We'll get indication from members in terms of your availability next Thursday. Hello? Yes, we can speak.
My hand is up. Yes, Chair, does this mean we are not going, our questions are not going to be answered today? Because all my questions that I asked are not answered. I'm not sure, I'm confused now. We ask questions, but are not answered.
Yes, Honorable Khotane, what do we want we want the department to give us based on questions we have asked? Is that the department must develop a process plan that will assist us towards ensuring that the bill is there and we comply with the Concord. So we do not want specific, we don't want them today to answer specific questions, but to bring a program to us that will answer to questions that we have raised, including all loopholes that we have identified. Your questions were very clear, they are straightforward, and we want them to answer us in a form of a program, but we also want the legal services to give us an opinion in terms of whether we go the executive route or whether we go the committee route, given the fact that we have lost 6 months, we're only left with 14 months. And according to Parliamentary Legal Services, is that going to next year for tabling the bill, we will be very late and we may be outmaneuvered by events to an extent that come December next year, we will not be ready with a full act in compliance with the court order. So we are weighing those options and looking at them. And only next week, when we get the feedback, is then that we will get a way forward. And we expect them to answer all questions at that meeting.
Okay.
Are we together? All right.
Yeah, good. Understood. Thank you.
No, thank you very much. Thank you very much once more to the Parliamentary Legal Services and to the department. We hope that you will try your best. If you can't deliver by next week, we are taking over. It's a done deal. We are very clear and resolute. We are not going to be constitutional delinquents who disrespect the Concord orders. It will not happen in this portfolio committee under our watch. I don't want to go to jail. I don't want to be charged for perjury or misleading Parliament. I thank you very much. Enjoy the day. You are released. Members can remain for the consideration of minutes.
Thank you, Chair.
Thank you very much.
Thank you, Chair.
Thank you very much. Nandipa, over to you with the minutes.
Yes, Chair, I've been asking General Ramontwana to please stop sharing so that I can share.
Okay, thank you.
Honorable members, these are the minutes of the 2nd of July, which was 2 weeks back. This was the agenda item briefing by the DMV on its amended strat plan, APP, and budget for 25-26. And also a briefing by the Castle Control Board on the amended strat plan, APP, and budget for 25-26. This was the attendance register. Any corrections on page 2? Page 3? page 4, and page 5.
Chair.
Okay.
Chairperson.
Yes.
Okay, page 5, on the recommendation.
All right.
The recommendations on page 5. There are 3 recommendations. They all 3 require dates. Can we perhaps put for the first, at the first bullet, the committee urges the department, the DMV, to fill all critical senior posts as a matter of urgency, and that a report be submitted to this committee, let's say by the end of August. Then, yeah, we can perhaps the last Wednesday of August on that date. I don't know what it is. Nandipa can perhaps put it in. That's my first recommendation. Then the second
is the 25th of August.
Yeah, is that the Wednesday, Chair? Yeah, 31st of August, fine.
The 25th.
Then the second bullet, the committee resolved that the DMV must submit a written report addressing unanswered questions. Same date, please. And then a report detailing all court cases. Same date, please. With those 3 recommendations, I would then, if that's supported, I would then recommend that we adopt the minutes. Thank you, Chair.
Thank you very much. I'm sure there's no indifference or any other view. We second your addition. Can we get a seconder?
Seconded, Chair.
Seconded by Honorable Hala. Any matters arising from the minutes? Oh, the minutes are adopted. Thank you very much. From the Secretariat, any announcement or anything? Dr. van Rensburg?
Chair, from my side, nothing. Just to thank members for taking this time, and we will then arrange the relevant meeting, short meeting for next week, Thursday. Thank you, Chair. Okay,
Nandipa, anything from your side?
No, that I was going to say the same thing, Chair. I'm covered.
You are covered. Okay, let me take this opportunity to thank all the members, the support staff, the minister, and the deputy minister, and all members of the Secretariat for their support, the department and the Parliamentary Legal Services. Thank you very much for your contribution to the Portfolio Committee. The meeting stands adjourned until next Thursday. Thursday, if there are caucuses in the morning, it means the meeting will be at 2 o'clock. We'll start 2 o'clock immediately after lunch, but that will be confirmed once we have heard indication from members whether they're attending their caucuses in the morning. Then if they are going to caucuses, then we'll start at 2 o'clock. Thank you very much. Until we meet next time, the meeting stands adjourned. Enjoy the day. Thank you very much. Thank you very much.
Thank you, Chair. Thank you.
Thank you.